All right, good morning. Am I loud enough there? Too loud? Back up. Is that good? All right,
How
perfect.
about me? Can you hear me? Okay, good.
All right, so good morning. Thanks for the introduction, Mahab. I'm Jeb. I know a lot of you, maybe most of you. I'm Jeb Girth. Was here last year doing this. Appreciate the opportunity to come back and update our case law. Kind of picking up where we were May 3rd, I think, last year, about this time. I'm pleased to be joined by Ann Knuckles Mahoney, my partner here in the Nashville office of Epstein Becker Green. We've got complementary employment practices. Ann focuses on corporate compliance, whereas I do more the litigation side. And so we thought it would be fun to, number one, you don't have to listen to me, a single person drone on for an hour. Number two, hopefully give a couple of different perspectives on this as we work through the cases. So with that, we will get started. If there are questions or comments, don't hesitate to raise your hand. Probably the best thing. I know we're trying to keep everything on tape, so we may need to repeat a comment or a question. So I will get us started. Our first group of cases is just we pulled a couple of Supreme Court cases, and with employment cases. The way we've done this before, and we'll kind of follow the same pattern today, is we'll hit a few Supreme Court cases, and then we will look at federal law. We focused on the Sixth Circuit, since this is a Tennessee law update, and we sit in the Sixth Circuit, rather than kind of a nationwide update on circuit level cases that are interesting. So mainly a Sixth Circuit update, and then we've grabbed a couple of Tennessee state law cases, primarily interesting Tennessee Human Rights Act cases, that we thought we would round out to make it truly a Tennessee case employment case law update. So with that, first case I thought we would talk about, the first two are going to be cases we talked about last year that were in a slightly different posture. The first is the Supreme Court's decision in Ames versus Ohio Department of Youth Services. The case was decided last June 5th. And so the decision came, I guess, about a month after our last meeting. So I talked about this one as it was postured on appeal from the Sixth Circuit. And we hit it right between oral argument in the Supreme Court. We had our meeting last year, and then the decision thereafter. It's just very quick background. This is used to be called a lot of times a reverse discrimination case, a claim of discrimination made by a member of the majority. So I think reverse discrimination has fallen out of favor, understandably, I think, because Title VII doesn't have is not directional. It prohibits discrimination generally based on protected characteristic of it. Those characteristics don't necessarily just flow one way forward or reverse. But it was a discrimination claim brought by a member of the majority class. In this case, it was a heterosexual woman who brought sexual orientation and sex discrimination claims. The gist of it is that she had claimed she'd been denied a promotion, and she was thereafter demoted. And she claimed that the circumstances around that and the person who received the promotion, who was a gay male, raised an inference of discrimination based on sexual orientation and sex. And that was where the case came up. The district court below granted summary judgment to the department. And it did so applying the Sixth Circuit's then existing background circumstances rule, which stated that if a member of a majority brought a claim, in addition to stating the standard prima facie elements, they also had to demonstrate background circumstances to explain why this is the unusual case where a member of the majority was being discriminated against. And the district court granted summary judgment. All the prima facie elements were met. The only thing that was missing was the background circumstances. And the Sixth Circuit affirmed. There was a dissent concurrence we talked about last time where the concurrence said that is the rule here in the Sixth Circuit, but it shouldn't be. And that's the way it went up to the Supreme Court. Quickly, and we had talked about this last year, but background circumstances, they had fallen into that last kind of quasi element for a majority claim was generally could be proved two different ways. One, a minority group decision maker. So remember, the majority, someone in minority was the decision maker, or statistics. I don't think it's really meant statistics as much as like a pattern practice kind of stuff. So that's the way you could do it. The reason it didn't work below is, in this case, is Ains. She was replaced by a gay male, but she originally believed, asserted the decision maker was also heterosexual. So she couldn't do it that way. And there wasn't a pattern of this. This is kind of this same decision maker. There were not enough decisions, a sample size, to say this looks like a pattern. So that's the reason why she couldn't satisfy the element here. The Supreme Court telegraphed that it, in oral argument, that it was probably not going to support the continued application of the background circumstances rule. And that is what happened. For all the reasons that you would probably suspect, that there's nothing in the statute in Title VII that suggests that. And it's just, it kind of is contrary to the spirit of the statute that prohibits discrimination to have different groups subject to different sets, evidentiary requirements just to get their foot in the door for a claim. And there's also some interesting stuff in the opinion about, is it always clear who the minority or majority group is, depending on where you are, and how those lines may not be as bright as one might think. So that was a decision not particularly surprising, and probably a result that tracks the statute closest. There's a concurrence by Justice Thomas that I won't delve into too much, but it's an interesting read. Justice Thomas takes the opportunity to say, this is just endemic of the problem of judges making up frameworks like McDonnell Douglas. That's not in the statute either, and it causes more trouble. It causes more problems than it solves, creates confusion and whatnot. So won't get into that now, but it's an interesting read if you were so bummed. Anything on that one, Anne, before we get in? Nope. Okay. Quickly, another case that was in front of the Supreme Court last year, but had not yet been decided. This one decided on June the 20th. Thanks. Stanley versus City of Sanford. This is essentially, the issue is a retiree's ability to bring an ADA claim while after retirement. The very quick background facts: a firefighter retired, took disability retirement. She was diagnosed with Parkinson's disease, retired in 2018, and when she was hired many years before, the city provided lifetime health benefits, paid health benefits for retirees, for the disability retirees. While she was employed, they changed that to limit it to only, she didn't know it, but they changed it to limit it to, I think, 24 months or 2 years of retiree medical benefits. So she found out after the fact, after she retired, and she sued under multiple claims, but including an ADA claim. And the issue was, could she bring an ADA claim because was she truly a qualified individual with a disability? And the statute requires to be a qualified individual, you have to be able to perform the essential functions of the employment position that such individual holds or desires. And the court concluded, affirming the 11th Circuit below, that means you either have to be in the position or desire to do the position. But once you are retired and can't do it, don't desire to do the position and can't do the position, you fall outside of the definition of a qualified individual. And that's how you get that is a requirement. That too has standing to bring an ADA claim. So a retiree cannot. There's a dissent by Justice Jackson that essentially says you really ought to take a snapshot of when someone was a qualified individual when they were earning the benefit back during employment. A good quote that put in the slide that captures her opinion says, that definition is designed to protect employers from employing those who can't do the work, not to cut off the rights of those who have already finished it. But that is the dissent. She was a sole dissenter. I think part of her, Sotomayor joined in part, but this was not like a split decision. It was a fairly large group of court that reached this result. Court also, the majority opinion also said that's just because of the definition of a qualified individual under the ADA. So the plaintiff may still have a Rehabilitation Act claim. There may be state law claims. So that's not, it's just a feature of the way the ADA is written. Just say broadly, there's a whole lot of retiree benefits, and retirees' rights to enforce benefits is a complicated area of the law. There are ERISA issues. This wouldn't raise ERISA concerns because this is a government plan, I bet. But there are ERISA issues for plans that provide for lifetime retiree medical benefits that are subsequently amended to reduce them, because welfare benefits typically aren't vested. And so there's a whole body of law around that and what it takes to enforce a promise for benefits. There are ADEA issues that are a little bit different with the retiree medical benefits. So I think my takeaway from this is that if the upside to this for companies who have retirement programs and offer some sort of benefits, at least this provides some clarity. There's a lot of issues to deal with that at least provides some clarity on the ADA piece of it. So you're not worried about it. You've got some clarity on what claims can be brought there, and then you can focus on that, the myriad of other claims that retiree entitlements entail.
All right, we'll move on to the Minnesota chapter of Associated Builders and Contractors versus Ellison. The Supreme Court actually denied cert in this, so there's not a true Supreme Court decision here, but still an interesting case to go through. And I think the denial of cert signifies something. This is about one of the Minnesota's captive audience fans. So those laws essentially prohibit employers from taking adverse action against employees for refusing to participate in meetings that may be about religious or political speech, such as union meetings. These laws, as Jeb Mokas mentioned, I focus in kind of multi-state compliance. So this has been a real trend throughout the nation. And these laws are been subject to challenges based on First Amendment and NLRA preemption. But for those who are con law nerds like me and get excited by issues like that, apologies, they did not get into the merits of those issues here. This is really more about a procedural issue in terms of standing. It was brought against the case was brought against the Attorney General, the Labor Commissioner, and the Governor in Minnesota. Of course, they claim sovereign immunity. And the district court denied the motion to dismiss for lack of standing based on sovereign immunity. And so the issue was whether under a principle in Ex parte Young, whether there's a narrow exception such that those state officials could actually be they could have the law challenge regards to their enforcement. Essentially, the Eighth Circuit, the Eighth Circuit Court of Appeals decided that the suit couldn't proceed against any of them, and that it left the captive audience ban in place. And then it analyzed that Ex parte Young exception, which essentially the official must have some connection with the enforcement and with the enforcement of the challenge law, and the threat. There must be a threat, and it must be about to commence proceedings. So it must be an immediate or imminent threat. Essentially, the case goes through the three state officials that I mentioned. The governor, essentially the court, the Eighth Circuit went through the idea of kind of appointing or removing a labor commissioner, and whether that's whether that has enough connection with the enforcement of the law, and found that was not a sufficient connection. Then looks to the labor commissioner's duties under the law, which essentially were there were mentions in the law, but essentially was like preparing an educational poster that now has to be posted about the law, and essentially found that those were only ministerial duties and not really enforcement duties. The Attorney General, of course, did have the ability under the law to enforce it, but there was no imminent threat of enforcement because the Attorney General and the Labor Commissioner specifically they submitted a declaration that they had no intent to enforce the law. Interestingly, the governor had kind of used the law in some public meetings, saying, anybody who violates that law is going to go to jail. And so essentially, there was an argument that he was kind of trying to enforce it, but that wasn't found to be sufficient in terms of the enforcement connection. So importantly, you kind of have to have that connection to enforcement, and there must actually be an imminent threat. What I thought interesting about this was, well, first, unfortunately, like I said, the court didn't get to the merits on the First Amendment and NLRA preemption issues. So I expect that those challenges will continue to persist, and we'll see what happens there. Also, I see this as sort of an indirect win in terms of drafting of state statutes, because these types of laws started out more direct in that they ban, like they would specifically ban speech, and now it's evolved more into not being able to retaliate against people for listening, for not wanting to listen to certain speech. So it kind of sort of got a little bit more palatable to people in that sense. And then further, what's interesting about the law is that the enforcement was really based on a private right of action instead of through the state. And so that was another way that the state sort of managed to uphold this law, because the enforcement piece was tied to the private right of action rather than necessarily the state action. And so, it allowed basically at this kind of early pre-enforcement state for the law to be upheld. And this was kind of one of the later laws to be enacted out of this trend. So it was just demonstrates an interesting evolution of the laws, and how the legislator can draft it such that it could hopefully be left intact. All right, we're gonna move on to Bruce versus Adams and Reese. I'm not gonna get into too many of the really nitty-gritty details on this one, but I will go through some of the facts. Basically, a legal assistant who eventually became a paralegal, who worked at Waller. She was subject to she alleges she was subject to sexual harassment and repeated sexually charged comments to and about her in the workplace. She, along with the group that she was working with, moved to A&R, and she was working there for about a year before she was terminated. She was terminated in May of 2023 in connection with some attendance issues, and her allegations were that those attendance issues were really related to failure to accommodate and engage in the interactive process. She had suffered through trauma as a child and had to take sedatives essentially to be able to sleep, and she started to have a delayed reaction to the sedatives that made her not be able to wake up on time. And she had previously, when she was at Waller, had more of a flexible schedule, but then at A&R she was held to a stricter schedule because of what the court describes as some her having some communication problems and thus needing to be at work in a more strict time. And so she alleges that she had tried to go through the interactive process, but essentially, she was late a couple more times, and then they fired her while being in the process of doing so. At A&R, she was subject to a broad employment arbitration agreement, and the employer sought dismissal of the harassment claim and to compel arbitration of the disability claim. Judge Trauger held that the Federal Arbitration Act is amended by the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, or EFAA, render the arbitration agreement enforceable as to the entire case. And so this Sixth Circuit case was about, first of all, kind of the normal issues that we're all probably very well aware of, is whether the complaint alleged sufficient facts to allege a claim that could survive the motion to dismiss. And what I found more interesting issue about this case was the matter of first impression about the EFAA, and whether, if there's multiple claims and one of those is a sexual harassment or sexual assault is does the plaintiffs have to arbitrate the other claims and can go through a court for the sexual harassment claim, or does it all have to be kept together? Okay, and so basically the court analyzed it, looked at things such as the text of the law. That's obviously where we want to start when we're interpreting any kind of law, and said the interpretation of the EFAA begins with the statutory text and ends there as well if the text is unambiguous. Looked at things such as Black Law Dictionary, Merriam-Webster, Civil Rules of Federal Procedure in terms of describing what a case or a claim was. The act itself refers to a case, and so they took what seems like a pretty reasonable position that it has to be the entire case. And so I thought one of the interesting points that A&R tried to point out was, tried to point to the FAA's long-standing presumption in favor of arbitration, but the court held that doesn't govern statutory interpretation. Really, that's used for applying general state law principles in terms of, interpreting the contract of the arbitration agreement and, what the scope of the arbitration clause is itself. And so we couldn't necessarily take that FAA, presumption of arbitration and apply that to the EFAA, which is actually an amendment to the FAA. And then in terms of, in terms of the first issue that I mentioned about, alleging sufficient facts, I thought there's one interesting little tidbit about that, or a couple. One, which makes a lot of sense, is that, I mentioned that this person worked at Waller and then worked at A&R. So the court was very clear to say that that anything that was alleged while the person was working at Waller could not be attributed to A&R. And then the next part was, essentially there were three specific examples of types of comments that were made. And the rest of the complaint describe the contact more generally, but did kind of say that it went that it was ongoing and that it continued when the person went to A&R. And so, as I mentioned, the court did find that there were sufficient facts, but there was a dissent in this case. And basically the dissenter says that it was really the rest of those comments, or what makes it seem like it was a continuing and ongoing or pervasive harassment was really just conclusory kind of allegations. It says the majority accepts these allegations establish a consistent pattern of sexualized jokes and comments without, so there wasn't really very clear evidence in the complaint about, when this how long this continued, what specifically happened at the new employer versus the old employer. So that's kind of an interesting takeaway if you ever find yourself in that situation again, in terms of being really clear about that. And then also, the main issue in this case around the EFAA was certainly an important one to keep in mind.
Okay, sticking with the harassment claim theme, a different take on it and a different rule to derive. Our next case is another Sixth Circuit case, Bibbins versus Zepp. This is one that was kind of got a lot of publicity, and so probably a lot of you have seen write-ups or notices about this. Interesting opinion. If you haven't read the opinion, I think this one is worth a read. It's not too long, and it's an interesting read. So the background is pretty easy to get your arms around. It's an employee who sells, I believe, cleaning products, and I think up in Michigan, in the Detroit area, and she goes to one of the customers she's assigned is a motel, and she goes in to the manager's office, and the allegation is she walks in, the manager locks the door behind her, and then says, I think, or says something like, I think we should date. And then apparently they don't date. She declines and she leaves. I think that's about the extent of the incident. And then she goes back to her company and complains about it. And her manager says, we'll take care of it. We'll reassign you into a different sales area so that you don't have to deal with that. You'd never have to call that person again. So that's the kind of the gist of the core of the kind of harassment part of this. She is subsequently terminated as part of a reduction in force. It looks like it really is a reduction of force. So after that, she brings claims for harassment as well as disparate treatment claims based on the termination. I think it's both discrimination and retaliation claims. Summary judgment is granted for the employer, and the case goes up to the Sixth Circuit, and the Sixth Circuit uses this as an opportunity to talk about the standard for when an employer can be liable for harassment by a third party, but in particular, they kind of focus on clients and customers, because that's what you got here. And the court, this is, again, it's a good opinion to read because it's the court really, I think this panel, the Sixth Circuit, really had an idea of where it wanted to go, how it wanted to lay out the analysis. And so it kind of starts at the beginning and really applies principles of agency to a harassment claim. So here's the kind of the way it works. Say that, an element of a harassment claim is corporate responsibility of some sort, which can be direct liability. So a high officer of the company harasses someone, the company's done it. Or it can be vicarious liability. But whatever it is, the ultimate question, the ultimate thing the plaintiff has to prove is intentional discrimination or intentional harassment in this case, but it's got to be intentional. And so the court says in order to do that, then direct liability, we'll set that aside. That's the owner, CEO, someone at a high level. For vicarious liability, agency principles are what you get there, what get you there. So by vicarious liability, you can have an act in furtherance of the employer's business. That doesn't normally happen. That doesn't really apply here as an agency principle, because most of us, at least on the corporate side, would say as soon as someone harasses someone, they have stepped outside of their agency, but they're not an agent for that purpose. So they have not acted in furtherance of our business. Another way an agent can bind their principal in harassment or make their principal liable for harassment is if the harasser was aided by the agency relationship. And of course, that's supervisor harassment. That's where a supervisor, because of the imbalance of power, supervisor uses that agency to facilitate the harassment. And so there's a standard for that, Farragut, Elliott, and all that kind of stuff. So that's another way an employer can be liable. The intent of its agent can be imputed to it. The third is an employer can be negligent or reckless in permitting the harassment. And that's coworker harassment. So the responsibility, it's kind of a negligent standard to make sure that you're not strictly liable for what a coworker does to another coworker, but if you were negligent or reckless, and if the employer were negligent or reckless, that's sufficient to impute the harasser's intent as an agent to the principal, to the company. But the court, then the Sixth Circuit says, but those are all agency principles. That you get there, you only get to that negligence standard because the harasser, the putative harasser, is your agent. And a customer or client is not the employer's agent. They are a third party. And so it's where the Sixth Circuit lands is, so that what gets you to that, a negligent standard would offend for third party harassment would offend the original concept that you got to get impute intent to the employer. And if you don't have agency to do it, employer-employee agency, and it's a third party, you can't get there. So the standard has to be, you got to get to intent some other way. And so when it comes to third party harassment, customer, coworker, customer or client harassment, in order to prove the necessary intent by the employer, you have to show the employer desired to cause the harassment, or harassment was substantially certain to result from whatever it is. So I think that views it as a higher standard. So that's the standard. That's what the Sixth Circuit has set. The EEOC, I'm sure a lot of you know, disagrees. The EEOC believes that for third-party harassment, the standard is negligence. And the Sixth Circuit notes in its opinion that most other circuits adhere to the EEOC's view. First, second, 8th, 9th, 10th, and 11th all apply some sort of negligence standard. So you might ask yourself, well, is the Sixth Circuit losing any sleep over going a different direction? The answer is, in the opinion, no. Nor do we lose any sleep over standing nearly alone in this conclusion. So happy to be where they are. I think it's the opinion, again, whether you, irrespective of how you feel about the standard that the Sixth Circuit has adopted, you can see that this panel went to great pains to kind of ground this in kind of its view of the logic of agency and how you get there. So it's worth a read for that, understanding it is outside of it is a split from what most other circuits have concluded should be the standard. There are cases that the Sixth Circuit noted for where this standard still, you can get employer liability, and I can't remember which circuit came out of, but an employer had assigned young, attractive women and instructed them to be especially cordial to a client and keep them satisfied. That would be, get you intended the harassment. You're asking, a worker to do something that expose themselves to something that would be unlawful. There was another case they cited where a mentally ill patient was grabbing a healthcare worker, and it was happening, repeatedly, and because of the condition of the patient, it was reasonable to assume it would continue to occur. And the court said that would be that would meet our standard. So in those cases, other courts applied a negligence standard. And the Sixth Circuit said this is the egregious cases you're worried about are still going to get picked up by the standard we've adopted. So what I would say to a high-level takeaways for me on this, number one, this is a higher bar than just a negligence standard. It's probably employers probably appreciate that. I think especially in what this is, like the single incident harassment claim, right? If it's repeated, so if we get into that, because if this was going to be a harassment claim, it's a single incident, it would have to hit the severity side. And I think a lot of you might debate it, but a lot of people might say, when someone locks the door behind you, that may get you, even if it's just verbal conduct, that may get you over the severity hurdle, even for a single incident. Reserving the right to argue the opposite on summary judgment if I have that case. But this is, you can see this might be applicable in that single incident case where a negligence standard might be a little bit more difficult for an employer to deal with. Like, what's perceivability? It's just, so it probably, I would think, offers some protections or perceived protections to companies, predominantly in that sort of circumstance. When it's a repeated thing, my guess would be you start to get, if you're on the pervasive side of the severe and pervasive, you open the door to you're knowingly exposing somebody to that conduct, which might get you closer to the Sixth Circuit standing. The last thing I'll say about this is I wonder, this is an employer who's sending salespeople out, and this happened off-site. I wonder if they could be viewed differently if this were workplace conduct. So imagine the case that a lot of this kind of circumstance, a lot of us have dealt with before, vendors who come in and repeatedly, catcall in the workplace that you have control over, that might be analyzed a little bit differently. So, all right. Yes. Excellent. So just for the recording, to make sure that Stephen just mentioned that the Supreme Court declined cert on an opportunity to resolve this dispute on the surface.
Right, we're gonna move on to Hightower Mathis versus Next Care Michigan Providers. This essentially took place involved conduct in an urgent care clinic. And the plaintiff was a patient service specialist or front desk employee. Um, on the given day, she was like how Jeb described this one. You can kind of tell from the facts where this one is going. But she was engaging in small talk with a police officer who came in. One of the small talk questions she asked was whether he had ever killed anyone. And he responds no, and she says, "Good for you." He didn't particularly like that. He texts his sergeant, who arrived to the clinic around 15 minutes later. And then this employee starts to have an interaction with the sergeant, and essentially asks the question like, how many people are you going to beat up tonight? And kind of gets in a sarcastic, stance with this sergeant. Doesn't want to give her name, doesn't want to give her supervisor's contact information, but eventually does. The officer reported the incident to the department, had the department called the clinic, let them know about it. And they complained to terminate their contract with the urgent care clinic. After a brief internal investigation, this individual was terminated for unprofessional conduct. The employee sued, alleging race and gender discrimination in a hostile work environment. Essentially, her core theory was that the defendant improperly credited the white officer or the white sergeant's take of the facts over her take of the facts. The Sixth Circuit affirmed summary judgment here, finding there was no prima facie case of discrimination because she had failed to provide any replacement evidence or replacement of suitable comparators. So basically, because she didn't offer any sort of evidence about a replacement, she needed to look to comparator evidence. The comparator evidence that she gave was pretty limited. She says a white woman from another clinic who was suspected of stealing money from the clinic was a comparator, but the plaintiff wasn't sure of her name, her position, and whether the company actually fired her. And then she gave another person as a comparator who was an African-American colleague who went off on patient, who was known to go off on patients. But again, didn't know the name, didn't know if this person got fired or quit. And essentially, basically, she raised comparators where she didn't have much information on those comparators. And the court's rationale was really there's no specific facts here as to whether or not they were true comparators. So they could find that there was a showing of genuine issue of material fact, and sort of the assertions about the credibility really can't be the assertions about credibility were really conclusory allegations and speculation, and those also can't create a genuine issue of material facts. Also, there was a hostile environment work claim, but the plaintiff admitted during her deposition that she didn't think she was fired because of her race or gender, but that she thought she was fired because they believed the white police officer over her. So they held basically based on that admission that the claim had to fail as a matter of law. And so essentially they didn't even get to her sort of pretext arguments because it failed on, she didn't establish a prima facie case. So this shows I don't know if I would say a strict standard in terms of comparators, but at least some standard where there has to be some specific facts. It obviously doesn't matter what her kind of subjective belief was. And I think this case essentially reinforces a kind of employer favorable application around comparators. The but-for causation concept, as well as the pretext issue where the court, decided not to even get to that issue at all.
Okay. All right. Our next case, Keene versus Brinker International, Inc. And I will tread carefully because I think there are counsel, perhaps in the room that have been involved in one way or this case, the other. And so I don't speak, don't purport to be an expert on everything in this case. One primary issue that we want to talk about in this one, it's an age discrimination case. I think it may still be pending. But there was an opinion out of the Sixth Circuit last June on an appeal of a motion for summary judgment. So in the issue that kind of we wanted to highlight is kind of really kind of an evidentiary one in the context of the McDonnell Douglas analysis of summary judgment. So quick background, the plaintiff is a 59-year-old general manager at Chili's in Nashville. He moves around, he's assigned to a Nashville store, gets moved to Murfreesboro. There are issues with, it appears to be from the records, some issues with friction with him and his manager. I think it's a director of operations. It looks like are above them. There are some complaints about him, at least alleged or suggested in the store. And all of this culminates in a decision by his management to terminate his employment. Before that, the complaints of it, that's kind of the background. The document part of this, or the evidence part of this, is it looks like and again, with apologies to anyone who knows exactly what the documentation looks like, it looks like the store used, your HR group used kind of an automated system for collecting information, especially for like an HR investigation. And not an uncommon thing to see where you got kind of a platform where notes can be added, where, the text or substance email can be pasted in to create a running and recording. I went and looked to see what it was, and it looks to me, the way I would describe it is kind of like you've seen like a claim file for a third-party administrator or someone that's administering a claim. They got a system that logs every touch on the file. It looks something like that to me, or a third-party administrator like that, FMLA administrator or something. So a file is created for a complaint against the investigation or complaint against this manager. He eventually is terminated. He's replaced by a younger general manager and brings a claim against his employer, including an age discrimination claim. So it goes to summary judgment, and I believe the employer was granted summary judgment in the trial court, in the district court. What comes up, though, and again, apologies for my summary of it, but what comes up is that this report, this kind of collection of things that happen in the investigation by a particular HR employee, is available. But the underlying emails and documents that went into it are not available. They, for whatever reason, were not retained by the time they got to court. And so you've got the report, but not the source method. And the district court apparently was okay with that, or would accept that. The Sixth Circuit did not. And interestingly, it launched into an analysis of the authenticity of that, which as I was reading the opinion, I thought, well, this is interesting. I would have thought that there might be issues with, kind of the credibility, if it's not the completion and things like that. But the court focused on authenticity and ultimately concluded that the document could not be authenticated. Under Federal Rule of Evidence 901, and so it was out. In my experience, it is not typical that authenticity comes up at summary judgment. I don't know how much. I think most of us probably were filing motions one way or the other. Have a declarant saying whatever document is what it says it is, or it's attached to a deposition. But that's what the court. That's where the court found it, and the court then said And so when I read that, I thought, oh my gosh, are we even going to get to pretext? Are they saying there's no evidence? Can you establish a legitimate or non-discriminatory reason without, a document? Court ultimately said yes. We're going to assume without deciding if the company has established a legitimate non-discriminatory reason, but without that document, that we don't think we can establish an authenticity, there's sufficient evidence of a fact issue on pretext. And so the claim gets kicked kind of at the pretext stage, but after that ruling on that evidentiary ruling on authenticity. So I think it's worth reading for that. I think most of us in practice don't typically think about authenticity. I went back and looked at the document, and at first blush, my thought was, and I'm sure others may have a different view, is that it kind of looks like a corporate record, that it wouldn't have to be the author to authenticate it necessarily, but a custodian, manager with custodial control over similar documents that are kept in, kind of a business record fashion would be sufficient to authenticate that document. An issue that comes up for those of us who defend cases, and, employees come and go. You don't always have all of the witnesses, and it is not uncommon to use a different witness to, a custodial witness authenticate a document. But the court here was focused on the putative author. It may have to do with the fact that it sounds, according to the Sixth Circuit, the author really disclaimed much knowledge about the document. And so that may have been what tipped the scale, as opposed to treating it more like a business record. But I would commend that opinion to reading, just because it's a unique issue, but you can see it could be a dispositive issue. And we don't typically, at least a lot of don't typically think about kind of that sort of evidentiary issue at the summary judgment stage. So it's I think a worthwhile reason for that book. Oh, I'm at stove. All right, switching away from harassment cases to a labor decision, and we will be brief on this because I don't know. Let's see, Bruce here. So I'm sure there are labor lawyers here that are more steeped in traditional labor law than I am. So wanted to hit on it because it's kind of this case got a fair amount of press too. It's a Sixth Circuit case from March of this year, so it's relatively recent. Brown-Forman Corp. Versus the National Labor Relations Board. So the background, it's a case that involves bourbon, and so that was a sufficient reason for me to put it on the docket. It comes out of Kentucky. I call it the Woodford case. It's Woodford Reserve. The facts are pretty straightforward. Woodford, I assume this was, I didn't look at the time, but I think it was, but bourbon is kind of in decline right now, but several years back, bourbon was kind of the rage. And so I think it happened during that period. And so Woodford was ramping up production, but at least according to workers, the ramp up in production and the additional work that required was not accompanied with corresponding increases in wages, which I sometimes hear that employees tend not to like. So some of the employees contacted the International Brotherhood of Teamsters, and they started kind of a campaign. Woodford raised wages $1. I assume that's hourly rates $1, and said, we're going to give you $1, but we're not doing this again this year. This is it. That made the Teamsters apparently a lot more attractive to the whiskey distillers. And so the campaign really got going to the point where the Teamsters eventually had like a majority of cards to trigger an election. And so in response to that, Woodford said, oh, we didn't take this seriously enough. Just kidding. Even though we said we're only going to raise wages $1, we'll raise them, and we're going to do it again. We're going to raise them $4 for everyone. And we're also going to change the pay progression policy. So your upside going forward is going to look better. And we're going to allow you more flexibility on vacation around Christmas, the end of the year holidays. And employees like that. And just to make sure they were on board, Woodford's having lots of required meetings with employees to tell them about how bad the union is and all the things the advantages of a company of management unfettered by cumbersome requirements of collective bargaining. Icing on the cake, Woodford gave everyone a bottle of Woodford Reserve, which I think is a nice thing. And so all of those actions apparently cooled interest in the union. And some employees said, I kind of feel like I was bribed, but I'm getting $4 an hour or more, and I got a bottle of bourbon. So the Woodford management won the election 45-14, and the union didn't like that, and they filed an unfair labor practice charge. And so there wasn't really any dispute over whether there was a fair labor practice. The issue was the remedy, and what the ALJ and then the board eventually did is they entered a bargaining order and said, way too many shenanigans. We're just recognizing the union, y'all don't bargain. And that's what came up with the Sixth Circuit. And the Sixth Circuit said two things happened. They entered a bargaining order. The NLRB first said, under the prior standard, under the Supreme Court's prior standard, it's appropriate here because the circumstances were so egregious, we don't think we can have a fair election. But then after the board said that, the board went further and said, we're going to adopt a new rule now because we've been dealing with a bunch of these, and we're going to make it easier to enter bargaining orders. So rather than essentially having to show that it would be impossible that a union had a majority at some point, it would really be impossible to have a fair election. We're going to adopt a rule where it's easier to go straight to a bargaining order. And that's what the court said. Sixth Circuit says, no, you can't adopt that rule. On a technical basis, that this was an adjudicated matter, and your adjudicative authority is to adjudicate a particular dispute, which you did when you applied the Supreme Court standard and said, we can't have a fair election here, so we're getting a bargaining order. But you went further and you adopted a prospective rule that we're not going to go through this entire process, and we're going to make it easier just to enter bargaining orders. And when you did that, you were no longer adjudicating, you were rulemaking without going through the rulemaking process. This should have been gone through rulemaking, where you're going to try to adopt a standard like that. And that's the essence of this. There's a dissent that says, no, NLRB is crazy and things change all the time, and lots of rules are made in an adjudicated way before. But that is the ruling of the Sixth Circuit on this. And I think that, probably not a huge surprise given the kind of the view on, restrictions on what agencies can do, kind of post-Loper right, and just a general view of kind of reducing or confining regulatory bodies to their core regulation. But that's the takeaway here.
All right, good transition there. This DOL versus America Healthcare Services is, in my opinion, more of an administrative law case, but certainly worth a read if you want to understand why administrative law can be relevant to you as an employment lawyer. Essentially, the DOL was bringing an enforcement action against a third-party home care services provider based on overtime violations. There are 2 exemptions that it had previously been relying on. But in 2013, the DOL promulgated a rule that barred third-party employers from invoking those exemptions. Essentially, I'm not going to go into too much detail since we're running out of time, but this case sets forth what the standard and sort of the analysis should look like when there is an express delegation of interpretive authority like there is in the FLSA to kind of define and delimit what the rules of the FLSA are to the DOL. And so it goes through what that analysis looks like. And one thing I thought that was kind of interesting, they don't, they point out the fact that Loper Bright doesn't necessarily mean that any Chevron-based decision is going to get thrown out. I like this quote. Mere reliance on Chevron cannot constitute a special justification for overruling such a holding, because to say a precedent relied on Chevron is at best just an argument that the precedent was wrongly decided. That's not enough to justify overruling a statutory precedent. So that was an interesting one, and I think the key takeaway here, other than, as I mentioned, understanding how the circuit is applying this Loper Bright standard within the circuit is make sure that you're keeping up with with what the changes are in the industry. This was an FLSA regulation that had changed. I mean, it's pretty specific and unique to this industry. But just a reminder to, particularly within healthcare, home care, to make sure you're following on what all the latest legal requirements are. Okay. This next case involved a Tennessee Highway Patrol trooper or probationary patrol trooper. She was a Russian born female in her late 40s. She responded to an incident. Several other troopers had already gotten there and had observed what they thought were some signs that the driver who had gotten into a crash was under the influence, and they encouraged her to submit the person to a sobriety test. She decided not to. Thought she was being compassionate to the driver who shared that she suffered from MS. She shared a medication list. On that medication list were several painkillers that can cause sleepiness, drowsiness. Essentially, this led to the person who the trooper who was there, who was really pushing her to administer a sobriety test, files a complaint. This led to an investigation, and ultimately the department, after recommendation from the Office of Professional Accountability, terminated this person. Where really this case boils down to kind of what the comparator issues are here. The department had a disciplinary matrix that it used, and essentially the comparators that she pointed out were not their level of infraction wasn't as severe as hers, and so the court found that they were not proper comparators, and then that the pointed to the fact that the defendant raised the fact that there was actually someone who had engaged in the same conduct who had been terminated. So it looked, I looked in terms of kind of different, what's the level of severity and the difference of discipline. So there were also some comments in this case, but the court found that those comments alone, hadn't really been tied sufficiently to the decision to terminate her. So obviously, as a kind of practicing, attorney, it reinforces the importance of consistency, which we all know very well is kind of one of the key rules in employment law, is to be consistent and applying your discipline, and in fact that helped the employer here. Also, the court, one interesting issue here was the court started to look at at another element of the prima facie case, in terms of whether she was actually qualified and whether she was meeting the expectations of her job. The court decided not to get there because of it relied on the fourth element around the comparators. But it does show some potential willingness to get into the issue of performance and whether that weighs into whether someone's qualified for the job, and whether that can be decided at that procedural process when we're looking more at the prima facie case. So that I thought that was interesting fact.
Why are we?
Yeah.
So I think that's a good case to read too, because in the most federal courts will say on whether you're qualified for the job, we're not going to deal with it at the prima facie stage. We'll pick it up further in the analysis. We'll kind of assume it for purposes of being there. So definitely worth to read from the Tennessee Court of Appeals under the THRA. We got a couple more cases. We are at time. I'll just say that we're interesting cases on kind of applying the elements of a crime facie case in the reduction of force context. Is an interesting case on kind of continuing application of the continuing violation doctrine and how that works, with some interesting facts to it. In addition to the slides, we've got a handout that an associate of ours put together. Caitlin Carlton did a nice job with it. And so all those are there. And so we commend that to you if there's any questions. There's a few other cases that are also that we thought that were interesting enough to summarize, but didn't put in the materials or whatnot. So please do take a look if you find anything interesting in there. Thank you for allowing me and Ann to spend some time with you. Hopefully there was something interesting in there that was helpful, and appreciate it very much.